Every day in the USA, people find themselves in court.
We are here in the case of Tiffany D. Augustino versus Don Smith, case number 23-07700-NI. This hearing is being recorded on Zoom and live streamed on YouTube.
Very good. And this matter comes before the court today on two motions for summary disposition by Assembly 911 Inc. I would invite counsel to place your opinions on opinions. Let's start with appearances on the record.
I'd be happy to start with my opinions, Your Honor, but Rick Houghton, Michigan Auto Law, on behalf of the plaintiff, Tiffany D. Agostino.
Thank you.
Your Honor, Attorney Regina Berlin and Kieran Kaur here on behalf of the moving party and defendant, Assembly 911 LLC.
Thank you.
And Burton May on behalf of defendant Don Smith appearing as well, Your Honor.
Very good. Thank you, Mr. May. Always nice to see you again.
You too.
Very well. Well, Ms. Berlin and Ms. Carr, this is your motion, and I'd like to take up the issue of whether or not he is an employee first. It seems to me that if I granted that, it would be dispositive as to whether or not he was working on the day, at work at the time of the alleged accident. So let's take that one first. Who's going to argue?
Your Honor, I will be handling that motion. Sister co-counsel Kieran Kaur will be handling the second one if we get to that point with respect to whether or not Mr. Smith was still working.
Very good.
With respect to our motion for summary disposition, it's Assembly 911's position that at the time of the motor vehicle accident, Austin Smith was the only one who had a contract to do work and build tough sheds with Assembly 911.
And you're not going to concede that Austin Smith was an employee at this point, although it seems to me that even if you did concede he was an employee, that's still not determinative as to Don Smith.
That's correct, Your Honor. So if we want to take a step backwards and discuss the contractual relationships or the relationships between the party, I'm happy to do that. So at the top, we have Tough Shed. Tough Shed manufactures these sheds and has a contract with Assembly 911 to have these sheds built. Assembly 911 then has an independent contractor relationship with Austin Smith at the time of the accident. Austin Smith then retains his father, Don Smith, the driver, to assist him in building the sheds. So at the time of the accident, there's at least another layer between Don Smith and Assembly 911. Even if you want to lump Austin and Don together and say that they're on the same team, they're still independent contractors of Assembly 911.
And I guess that brings me to my first question. The plaintiff raises the existence of the non-compete agreement, which does say throughout that these are employees. And it looks like 911's principal said, I agree. That refers to them as employees. Can they be employees for purposes of the non-compete, but still independent contractors for this case?
The purpose of the non-compete agreement was to prevent their independent contractors from directly soliciting work from Tough Shed and kind of going around them. That document was not an employment contract. That document was not intended to create a employee-employer relationship. It was the intent of that document, like I said, was to prevent Assembly 911's independent contractors from soliciting Tough Shed's work directly.
Understandably, and I guess you are answering my question in that even though it refers to them throughout as employees, and uses that language, they still could be independent contractors in terms of the actual work they're performing applicable. This isn't a question about them competing with Tough Shed. After all, this is a question, or competing with Assembly 911. This is the question today: is were they employees at the time of the accident?
That's correct.
Okay.
And in my reply, I analyze the case, let me make sure I'm saying it right, Hoffman versus JDM Associates. And I think that case is quite analogous to this situation, where Manpower, doing business as JDM Associates, clearly has employees. And then they send their employees to this shop to do work. And in that case, the court found that those individuals, with respect to the shop, were employees. They did not associate any sort of employee or respondeat superior, I should say, liability to Manpower. And that's very analogous to what is happening here. Assembly 911 is finding independent contractors, is finding folks and sending them out to build sheds for Tough Shed.
Okay, much like Manpower might say, I've got a pool of available temporary employees that I have contact with, and I am going to send them to companies. They may indeed become employees at companies, because I can imagine when a Manpower employee arrives, the company says, okay, you show up at this time, you do this amount of work, here's your supervisor, here's the bathroom you use, et cetera, et cetera, et cetera. Manpower may still cut them a check, but at the end of the day, their day-to-day activities are very tightly controlled by the assigned employer. That's
correct. And in that case, Manpower had far more control and contacts and requirements of their employees than Assembly 911 does.
Yes, and right, and I guess it sort of begs the question in this case, could there be a scenario where someone like the Smiths are out there working and there is no employment relationship? Everyone's in effect an independent contractor. Unlike the Manpower case, where eventually we get down to an employer, here you're saying we never got enough specific. Well, I mean, we did have an employer in the sense that perhaps Austin Smith was self-employed and perhaps employed his dad, Don Smith, as a de facto employee because they had to coordinate those details together, but none of the corporate entities got involved.
Correct.
Okay. All right. I think I understand that portion of the argument. Thank you. You may continue.
Well, Your Honor, unless there's something else specific that you'd like me to address, I'm happy to do so. But otherwise, I'm going to rely on our motion and reply in the exhibits attached thereto with respect to the issue as to whether or not Don Smith had an employer-employee relationship with Assembly 911, which we maintain he did not.
Very good. Something that was unclear after reviewing the briefs to me was who owns that app? Is that Assembly 911's app, or is that Tough Shed's app?
That is Tough Shed's app, and Tough Shed retained Salesforce to design the app. Both Mr. Ordaway and Mr. Bayless testified unequivocally that they do not have access to the app, to the information that's on the app. They can't see the contractors' profiles. They can't access that information. Now, to be fair, I believe it was Mr. Bayless testified that he created his own profile. So, because he was going to do jobs for Tough Shed, so that he could see what his independent contractors were using and in case he could talk them through something. But with respect to accessing the information, they don't have access to any of the information that the independent contractors input or upload to the app. All of that
Yeah.
is at the discretion and control of Tough Shed.
Right, and it appears that, for example, if a shed doesn't get built, and a customer calls and says, "Hey, I thought I paid for this build, in addition to the materials from Tough Shed," they call Tough Shed, and then Tough Shed would check, presumably, its app to see if its contractor went out there and showed up on the job site and built and sent pictures and things like that, and if that was, and then they would relay that information to assembly, who would then go about fixing the problem, be it by sending the original contractor back, or perhaps redirecting a separate independent contractor to backfill, or what's that called under the commercial code, where you provide a equivalent services, even though it's not the originally assigned person, I guess. Is that how that worked?
Yes, Your Honor.
Okay, all right, very good. Well, let me hear from, I guess, before I go to plaintiff's counsel, I'll solicit any input from Mr. May as Don Smith's counsel.
Your Honor, we filed a concurrence in plaintiff's response. I didn't file a separate brief, but generally, I mean, one of the things I believe that we need to look at here is what Don Smith was led to believe by Assembly 911, and his testimony is pretty clear that he was led to believe that he was an employee. He was paid directly. He said there was an initial very short time frame that his son Austin was paid, and then Austin would pay him, but then soon thereafter and before this accident happened, he was getting paid directly. And that it was his understanding he was employed by Assembly 911. They controlled, through the apps and stuff, it was controlled where he went and when things had to be done. So that's important. He had to report, as far as progress on the completion. But I think the other thing that's super important here is, Tough Shed tells Assembly 911, you need to carry insurance to cover these, as they put it, the term employees, including automobile liability insurance. And Assembly 911 does that. They take out the insurance policies, but then apparently don't make them available to these workers, whether you want to call them employees or not. Everything that was done.
Well, this is like a pizza delivery driver. I mean, they're not going to give you an individual coverage for your own vehicle or in your own name. Rather, they might take out an automobile, but the coverage for the automobile, and I think it was actually referred to, I did review that, as someone who's, non-covered or non-owned and hired coverage. Isn't that the only thing that insurance was to do? I mean, after all, it's only to protect, I would presume. I saw that requirement in the contract, but it seems like it's there to, protect Tough Shed. They're saying we don't want any upstream liability. If one of your employees gets in an accident, you better get some coverage.
Yeah, but Don Smith testified that he was told that he would be covered, and I mean, you have an unsophisticated person here who's being told one thing by the company that he thinks he's working for, but they're actually behind the scenes doing something else. I think that becomes a jury question on whether it was reasonable for him to believe those representations and rely on them.
Agreed, as to unsophisticated, but he did carry a policy. I mean, even if he was told, we're going to provide insurance for you, he didn't take that to cover his auto. He carried a separate auto policy, thus your presence on the case, right?
Well, yes, Your Honor, but I mean, he would have to carry it anyway because that vehicle wasn't used only for work purposes. So he can't drive on Michigan roads unless it's insured.
Right.
If it was,
he didn't rely on Tough Shed or 911 saying, oh, by the way, we got auto coverage. Don't worry about that stuff. He was sophisticated enough to know that, right, for whatever reason, because of multiple use of the vehicle or because there's a Michigan insurance requirement, that he needed to purchase a policy of no fault to be legal in Michigan.
Right.
Yeah, and I agree that insurance requirements there, but I guess when I kind of step back from it, I think, well, what are they really trying to do here? And it certainly envisages that there could be vehicles, because I think it says, there could be autos owned, and I suppose perhaps, in some state, maybe there are tough shed vans driving around, but this wasn't that case. There's no question here that this
there's
was
no question
Don's,
this was his
his
privately
car.
owned vehicle.
Yeah. Yeah. And they didn't go so far as to name him or his vehicle as covered under the policy of insurance purchased for automobiles by 911.
I don't know
accurate?
with the way it was explained to me and the turnover and people doing the work and not doing the work. I'm not sure how viable. It would seem that they might be contacting their agent pretty regularly to change who is and isn't covered. But again,
it would almost be impossible.
All we have is my client's testimony, as to his understanding of what was going on here. And I think that raises some questions of fact. But as to the remainder, I defer to Mr. Houghton, because I did simply file a concurrence in his response.
Very good. Well, I value your knowledge as to insurance coverage in the matter, Mr. May, but Mr. Houghton's knowledgeable too. I'll turn to him at this time.
Thank you.
Mr. Houghton's like a racehorse chomping at the bit to get out of the gate over here.
All right. Go ahead, Mr. Houghton.
One thing I love to watch is when defense counsel wants to rely on deposition testimony when it behooves them, but then argues in their brief that deposition testimony isn't sufficient. It's just ironic. Ultimately,
and which testimony was argued as insufficient in this particular matter? I didn't
it's not in this matter, Your Honor. It's in the next matter that we'll hopefully get to. But my point to that is that it is a situation of talking out both sides of the mouth. And ultimately, Your Honor, there's no objective evidence that this app was owned by Tough Shed. There's none. Ms. Berlin pointed you to some discovery responses from Tough Shed, and all they said in that was, who made the app? Salesforce. Nobody disputes that. But again, there's no objective evidence to that. It's just the testimony of Mr. Bayless and Mr. Ordway. Mr. Smith.
And I guess their testimony is, I don't own the app. I can't, modify the internal workings of the app. That's someone else. They're saying, not certainly that it's Tough Shed. It could be Salesforce or whoever, but it sounds like their argument is we're beholden to the limitations of the app, pretty much the same as the installers are.
I can agree to that summarization, Your Honor.
Okay. No, that was an important question, because I mean, the one common reference in everyone's testimony here is, boy, we worked through that app a lot. So, and the deposition testimony of both Mr. Smiths was that it was their understanding that the app was controlled by Assembly 911, that's who they were getting this stuff from. And so it comes down to, again, like Mr. May said, a credibility issue on some of these things. And let's kind of go through some of your questions in order, Your Honor. So one of your questions was the purpose of the non-compete, and Ms. Berlin made wonderful arguments on my behalf there, which is the purpose of the non-compete is that these individuals don't solicit work from Tough Shed directly. That is an element of control. That is completely against the grain of what independent contractors are. The independent contractors, when your subcontractor gets hired by your general contractor on a construction site, they're free to go to competitors. They're free to go wherever they want. Maybe they don't because they have a good relationship with the general, but that's irrelevant to the question here. The point is, the purpose of the non-compete is to hold these individuals within the Assembly 911 realm, so that way they continue to do work for them and they don't get this work from competitors or from Tough Shed directly.
I apologize, Your Honor. I'm only 3 days post having the flu and being down and out, so I will probably stutter and get myself trapped here a couple times in my own words.
Seem to be doing fine, Mr. Houghton. You may proceed.
To answer your next question, I don't think that you can be an employee for the purpose of the non-compete and then an independent contractor for the purpose of doing work out in the real world. That's the entire premise, is if you are an employee for the non-compete, you're going to be an employee across the board. Which brings us to maybe the single
Why would
most
that be true? And I guess I'm thinking here of, perhaps a physician's practice where he's in league with other physicians, but, he's an independent contractor himself, or, or for that matter, an attorney who is not at a firm, but perhaps in, a practice or, a group with other attorneys, attorney's not a good example because we can't do non-competes. Let's use the physician. And the physician says, I'm not going to go out and recruit my own dental patients or my own spine patients in addition to the ones that come in the door here. I'm going to limit myself to those coming through the door. But in terms of his work and surgeries, he does not exclusively do them through the practice. Perhaps he works at several different hospitals where he has privileges and is in that respect an independent contractor. Why can't a person be different statuses depending on the question, the legal question?
Your Honor, in the physician relationship, if you have a non-compete with the group that you work with, when you go and do your surgery at another hospital, whatever their facility, you're not violating that non-compete. You are doing your work with that group in the context of the facility. You still would be an employee with your group, which is what we're talking about here, that when you go out into the world to perform the acts of your employer in that situation, you're not changing your status, you're performing it where it needs to be performed. And that's exactly what the Smiths were doing.
Okay, yeah, I think I understand the distinction there. And now the Smiths, when they were doing this, they didn't wear a Assembly 911 shirt, or did they have a badge? Did they have anything that indicated who they worked for vis-a-vis the customers?
They had a badge that said Home Depot on it. So you want to add another layer of
no, I don't want to do that for sure.
I can bring Home Depot in if you give me permission.
Talk about a deep pocket. Well, you'd think anyway. So no, I think we're far enough afield here. So I get it. And I've thought about this in the context of I'm an ardent reader of Home Depot, Lowe's, and Menards ads. Of course, I even read their inserts in the paper still. And I always note they say, well, if you want to pay an extra few bucks, we can have this thing assembled for you. And I've always wondered, who'd show up on my doorstep to build the shed if I did that. So I haven't pulled the trigger yet on any of those sheds. Like most of my projects, those are notional only. So but I get it right. At the end of the day, the customer would kind of expect someone to have a Home Depot or a badge on, and that's probably thus the badge that they wear with their name, etc. on it. It would be related to Home Depot. Okay. Well, why don't you continue, Mr. Houghton?
And so, Your Honor, we get to the all-important point, which is this Austin Smith versus Don Smith piece. And I explored that ad nauseum at both depositions, both in Florida and Pennsylvania, which I appreciate, Your Honor. I had a wonderful trip to the Florida Keys. And so, ultimately, the answers that I received were, we can't tell you why Don Smith doesn't have these documents signed, which has always been my point. And it kind of goes to some of our points in our arguments where defense is saying, well, you can't use lack of documents as evidence, but it goes to the point of these individuals don't keep records that are sufficient for proofs on this case. Ultimately, what I did walk both of these individuals through was that they acknowledged that likely Don Smith had all the proper paperwork filled out prior to, based on walking through Austin Smith's paperwork. And ultimately, that was what we got to. Now, I can't prove it because nothing that they have is dated, Your Honor, from Don Smith. It's all just, here's his signature. Here's the date we think he probably figured it out, which both Mr. Bayless and Mr. Ordway agreed with me upon if you read the transcripts in full. And ultimately, it's why I wanted some of these documents from them, including the direct deposit. Mr. Don Smith was receiving direct payments from Assembly 911 at a minimum a month before the crash. I think it was like a month and a half. So all these arguments, and by the way, one of the things that we got out of Mr. Bayless and Mr. Ordway is Mr. Don Smith is not allowed on a job site unless he has the proper credentials from them. So to argue that he wasn't credentialed, which Ms. Berlin does in her brief, is just a patently false statement. Mr. Ordway and Mr. Bayless said he couldn't go on a job site. They wouldn't have allowed him. Even as a helper, that they wouldn't be allowed on there. So
is that provided in the contract? That, because I thought the contract I read, the 911 contract anyway, indicated that they would have their independent contractors, and then of course those independent contractors could also hire additional employees to help out. It kind of envisioned a multi-layered relationship. That's not correct?
The contract between Assembly 911 and Tough Shed does state that nobody can go on a job site unless they have the proper credentialing, i.e. badges, because the customers need to know who is there. The customers need to have a right to know that they are the right people and that you don't just have random Joe Schmoes showing up off the street doing these things. That is in that contract. And Mr. Bayless and Mr. Ordway confirmed that in their depositions.
Sure, and that is because obviously you would not want to send a convicted rapist or mass murderer out to your customers' job sites unbeknownst to anyone to perform this work. That you would want some degree of assurance. But my understanding is Tough Shed did all the background checks and things of that nature, and ultimately gave the thumbs up or thumbs down to anyone that went to a job site. Isn't that correct?
My understanding from the depositions was actually that Home Depot does it.
Ah, okay. Yeah. So someone upstream does it anyway. Yeah. And I mean, it seems to me, and I think it's stated in defendant's brief here that they're saying, really, we want you to treat Assembly 911, maybe like paychecks, where we get invoices, we distribute payments, and thus the payment to Don Smith, but really we don't exert any additional control over how these employees do their work. And if anyone does that, why, it's Tough Shed, it's the upstream people. And all we do is we, serve maybe as a conduit for that information to them. But mainly what we do is we, take in payments and cut paychecks.
Well, I wouldn't liken them to paychecks per se, but if they want to reincorporate as a temp agency like Manpower, which Ms. Berlin relies on pretty extensively, then maybe they could. But that's not what we're talking about right now. They're not that. They're not a temp agency. Manpower is a temp agency. We know that they are an agency that gets people specifically for many companies. Whereas Assembly 911 works directly with Tough Shed and getting employees to work with Tough Shed and accomplish the jobs of those two entities. Tough Shed is the only company, if I remember the deposition transcripts correctly, that they do work for. That might not be true. There might have been some others for Windows and stuff like that, but they all came through Home Depot, I believe. But that's why I asked the question of Mr. Bayless. If you were not related to Assembly 911, if you were just coming into this for the first time and I handed you this document, I didn't ask him, would you think he was employee? No. I said, what would you believe? And his answer was that Austin Smith could be an employee. Again, that's because I don't have any other signed documents because nobody can explain to me why Don Smith, who they acknowledge, at least when Austin Smith is gone, was working for them. I'm not going to call him an employee. I was very careful about that during my depositions, Your Honor, to not just call him an employee, because ultimately we know Austin Smith, shortly after this crash, quit, but yet never Never is there a document signed by Don Smith for all these things. So we don't know when any of this actually fully happened, because again, I come back to the point of these are credibility issues. These are questions for a jury because they cannot prove any of this objectively. It's based on testimony of Mr. Bayless and Mr. Ordway saying, this is what we did, this is how we did it. And the deposition testimony of Mr. Smith and Mr. Smith saying, this is what we believe, this is how we did it, this is what happened.
Okay. Well, and I as I'm examining this from a purely legal perspective, and I don't, because I think I could say, well, certainly, perhaps, Assembly 911 might be an agent of Tough Shed and thereby an agent or whatever, relation back to Home Depot. However, when we get down to the nitty gritty, indeed, the two employees involved in this case, I'm trying to go through that, and it seems like both parties agree that the test to be applied is what we call the economic realities test. And number one in that test, I agree with you. If we went solely by the payment of wages, no question, the paycheck came, with Assembly 911 address and name on it from them, that would be definitive and he would be an employee. However, I do think that, it does hinge on, all of the factors of the test. And number one there is control. And it appears to me that Don Smith and Austin Smith could pretty much go where they wanted, when they wanted, and quit whether they want, not quit totally, although I suppose they could do that too, but stop working, if they had a kid's, birthday party or something, rather than saying, oh, we're going to work till 5 today, like you would if you were working in the store at Home Depot. You'd say, you know what, we're going to knock off at 2 today. We'll get at this thing again 9 a.m. tomorrow morning. And that Assembly 911 had absolutely no input as to what that looked like. Is that accurate?
Your Honor, I think based on the testimony of Mr. Bayless and Mr. Ordway, that's accurate. And I would argue, Your Honor, that's exactly how I work. Unless you tell me I have to be here at 11 a.m., my employer has no control of me. Would we argue that I'm not an employee of Michigan auto law? Well, come on, Your Honor, that'd be ludicrous. We know that.
Well, I having been an employee of a couple of law firms and a partner in one in the past, I hesitate to analogize law firm relationships to anything else. But I guess, when you get to that economic realities test, and of course, the old test was the control test. So it seems like control is an important factor to consider. And reading through this, even, in the limited, because I agree, and particularly when you get down to was he working at the time? Well, it appears that, they had, at least in the Smith's mind, finished up one job and they were moving on to another job that, doesn't appear for whatever reason on the schedule or in the app, but, a prior contractor had dropped the ball on and not finished. Were they doing that because 911 told them, hey, at 2:00, you got to get over there and finish that job? Or did they just say, hey, we can pick up some additional work here and let's do that because, of our level of independence? Which one was it in your mind?
Your Honor, I think they're doing it because they were told to by the app. And ultimately, what we're starting to create is the framework for a shell.
Sure.
And literally, we have an insurance policy that applies to nobody. Sean Bayless and Chris Ordway acknowledge that. They have no employees, according to them, that would fall under that in any state. They own no vehicles, and their personal vehicles aren't insured by this policy. So we have an insurance policy.
You said
they are not.
Well,
they
I
both
was
testified to that.
That they were both driving, loaded Yukons with the insurance policy, like most corporation owners do. But I digress. So,
right. Well, I thought the same thing, Your Honor. There at least should be something. But according to them, this policy stands for nothing. It insures nobody. And if we head down this path all the way, what we've encouraged is Tough Shed to use Assembly 911 to create a shell of liability that they're putting people on the roads of Michigan with no liability for the actions while they are doing work for them, forgetting about, just take a step back. Don't use the word employee. We know that they are doing work for them. Forget about if we're deciding on the second motion or not. Forget about that. Assuming this, they're driving to the job, they're driving to another job. For one moment, humor me. Our point, the laws of the state of Michigan insulate these companies so they can do this with no general liability out there. That's what we are walking towards if we continue to walk down this path, is encouraging companies to do this in the state of Michigan and leave the general public open. I think we get there based on the facts. I think we've created enough of a fact question to leave this for a jury, but also public policy and having this illusory insurance contract that does nothing cuts really hard against this, Your Honor.
Well, that sounds like the dream insurance policy for the insurer, right? No real exposure, and I collect $30,000 a year worth of premium. If I was an insurance company, I'd be overjoyed at issuing that policy. But I see what you're saying, right? The more attenuated we allow, even if these are subcontractors to become, what's the point of an insurance policy and coverage and protection of the general public? I hear that argument.
Especially one purchased for non-owned autos. And Your Honor, I will tell you right now, if this is the road we're walking, I'll insure Assembly 911 for $100 million for the same price because there's no risk. And that's my point to this is I think we get there based on the testimony of, especially of Sean Bayless. Chris Ordway, forget about him. He was whatever. Sean Bayless walked through these contracts. The contract with Assembly 911 and Tough Shed, and the documents with Austin Smith, because again, we don't have any documents for Don Smith, but we did have some documents for Don Smith. I shouldn't say that, because we have his background application that is there that has the date that he lived to his certain address. You can read that transcript if you're so inclined, or I can find it for you. But
it doesn't have the dates that he submitted the background application, though.
Correct. We kind of got there in a roundabout way through common sense, but there's no date that Mr. Don Smith signed it on the document. That is correct. They used something which I couldn't be provided with, which I asked for. The proofs, when we use DocuSign, I can get a proof of signature. The whatever format Mr. Ordway is using, he can't provide me with that proof of signature. So Ultimately, Your Honor, when you kind of look at this, you look at what the requirements of Tough Shed were. You look at all the documents that they have these guys signing. You look at the date that is filled in for when Mr. Don Smith lived at his address too, which you can, again, humor yourself in the transcript if you so choose. I think those in themselves point to either these guys are employees, they were held up to the public as employees, or they need to be found legally to be employees for the purpose of this case.
All right. Thank you, Mr. Houghton. I'll go back to Ms. Berlin for a reply.
Certainly. Your Honor, I would like to, let's see, am I permitted to share my screen? Yes.
Yeah, certainly.
Thank you so much. So on Exhibit A, which is the contract between Tough Shed and Assembly 911, page 8 of 11 of that contract, I've got it highlighted right here, indicates that Tough Shed, at its discretion, requires the installers to utilize the application. Here is objective proof to satisfy Mr. Houghton that Tough Shed is the owner, the controller of the app, and the app was designed by Salesforce. With respect to this insurance issue about Assembly 911 carrying workers' compensation insurance, about carrying auto insurance, that's a red herring, Your Honor. The economic reality test and the control test do not require an inquiry into the employer's insurance policies. And there's no case law. Mr. Houghton did not produce any case law that would require this court to consider who, what an employer insures. It's a red herring, Your Honor.
And I guess it's normal practice, for lack of a better term, at least in the corporate world, to have somewhat overlapping coverage, and that's because of the desire of large corporations not to be liable at the end of the day for a huge judgment, even if they don't think it ought to be against them. Sometimes they insure against more remote possibilities.
That's correct, Your Honor. And so unless there's something else specific you'd like me to address, I'm happy to do so. Otherwise, I think we flushed out all the issues with respect to whether or not Mr. Don Smith was an employee of Assembly 911. And it's our position that the objective proofs and the documentation prove that he was an independent contractor to Austin Smith and has no employee-employer relationship with Assembly 911.
Well, I'm going to go ask you this question on, because I think the insurance, if anywhere, in the control test goes to this factor number 4, which I didn't quite get to with Mr. Houghton, but I guess we touched on anyways. And factor 4 is the performance of the duties. And of course, those are the duties in number 1 that are controlled as an integral part of the employer's business towards the accomplishment of a common goal. Boy, talk about breadth of language there. That could encompass a lot of things. But at the end of the day, there is the testimony, and I think this goes to Mr. Houghton's argument here as to why should we let 911 off the hook when they are clearly engaged with these employees, and they admit, hey, there's no way we can run this business without these workers on boots on the ground, as it is down in Austin Smith, and they are integral parts. There is no business without the two of them, and of course the common goal there is it's right in Assembly 911's name. We're assembling sheds or assembling stuff. That's the common goal. Why wouldn't I find that as to be in the plaintiff's favor here and say, there's just too much here that is on the record to at least create a fact question, if not be dispositive on that they're working towards a common goal?
The primary purpose for Assembly 911 is to act as a payroll company and a recruiter. That's their business model. That's their goal. They do not own construction equipment. They do not manufacture the sheds. They do not provide instructions on how the sheds should be assembled. All of that comes from Tough Shed. I suppose one could argue that their common goal is to make sure that tough sheds are built, but to the extent that they have control over whether or not those sheds are being built, that is done through the app, through Tough Shed. That is not done through Assembly 911, at least through Assembly 911's owners.
Okay, I think I understand the argument. All right, well, I'm gonna rule on this one.
Your Honor,
go ahead. Yeah,
if I may, I know Ms. Berlin gets the last word, but there's two important things here. First and foremost is that's Ms. Berlin's statement of a payroll company is not what Assembly 911's website says on their About Us, which is Assembly 911 assembles prefabricated sheds across the U.S. We also install windows and doors. That's point one. Point two, and I alluded to this throughout, there's no independent contractor agreement between Assembly 911 and anybody, the Smiths, any of their contracts that I've ever been given. The only place the words independent contractor come up is talking about the relationship between Assembly 911 and Tough Shed. That's right. All. I'll let Ms. Berlin respond.
And they want to say, of course, Tough Shed and Home Depot, et cetera, all want to say 911 is an independent contractor, not an employee or agent of their corporations, correct?
Yes, Your Honor.
Yeah, no, Ellen, I mean, it occurs to me here, and I will put my opinion in order on the record at this time. That this case illustrates both the confluence of modern technology and the efforts that corporations utilize under the corporate form to insulate themselves from liability downstream. And after all, that perhaps is the very reason for the existence of the corporate form in the first place, so that I can own stock in Home Depot. Actually, I don't know if Home Depot is even a public company, and I shouldn't throw that out there as an example, because if I did own it, we'd have a whole argument about conflicts of interest. I have no idea if I own it, of course, through a fund or something of that nature. But in the case of public companies, the whole purpose of the corporate form is to insulate their actual owners, the shareholders, from that downstream liability for individual acts that might be committed by the corporation. And, so that's part of this. And then the second part of this is, the reality of the way employment and independent contracting, and for lack of a better term, gig work, works in the modern economy, and that there are many workers these days who go on various applications and electronic platforms and perform discrete bits of work to the requirements that are set by someone out there, but are communicated to them through that electronic platform. That is, what the scope of the work is to be, and when is the date it's to be completed by, et cetera, et cetera. And that's something that was probably unknown when I started practicing law in 1995, but is certainly a total feature of the modern economy, and illustrated perhaps by the Tough Shed app, which does specify certain things that it expects to be done by its subcontractors here. The first of which is Assembly 911, and the second, subcontractors involved are the actual boots on the ground, the subcontractors who are Don and Austin Smith. But however, under application of traditional, the economic realities test, which both parties reference in their briefing, I cannot find that they were employees of Assembly 911. They were independent contractors, and I'll give you the reasons for that finding at this time. And the test I'm taking comes from the Michigan Supreme Court, the economic realities test. I am going to cite to that's Askew versus Macomber. That's 398 Mich 212, 1976 case. And also a little more recently, Clark versus United Technologies Auto Incorporated, 459 Mich 681, 1999 case of the Supreme Court. And that gives 4 elements to the economic realities test. And there's one here. Element number 2 is the payment of wages. And that one clearly goes in the favor of them being employees, because there is no dispute that wages were paid to both Don and Austin Smith directly by Assembly 911. However, it's the other components of the test where we the claim that their employees fall short. And number 1, first and foremost, and I think, just as a point of reference, the predecessor to the economic realities test was the control test. In fact, I recall when I began practicing law and analyzing employment relationships, the control test was always first and foremost, and that is the ability to control the worker's duties. And the question becomes, well, what duties are we talking about? And of course, those duties are multi-pronged. First of all, when do you show up, and what uniform do you wear to show up to work, if any? do you have to drive a company vehicle? Do you drive your own vehicle? Can you show up at 5 in the morning to build this shed, or do you have to hold off until 8 in the morning when the customer is going to be awake? Of course, how long does it take you to build a shed? Can you be on the job site for 5 hours? Do you have to do it all in one continuous build, or can you split it into 2 different days? Do you put up the walls first, or do you put on the shingles first? Do you use only materials supplied by the either Assembly 911 or Tough Shed, or do you utilize your own tools and wherewithal? Is there an employment manual that governs some of these things and instructs you? Is there not? And ultimately, of course, the terms for your pay when you do this. Are you getting paid on an hourly basis, or as it appears to be in this case, a per job basis for undertaking these contracts and completing this work? And of course, any quality assurances that need to be put up. Who has the final say? Does the customer get to specify the quality? Does an inspector from 911 or Tough Shed come out to each job site and measure the corners and see that they're 90 degrees and that the shed is level, et cetera, et cetera? Or is that something that's discussed with customers and conveyed backwards through photographs and things of that nature? And it appears to the court in this case that Assembly 911, though it did, in common with its independent contractors, utilize this app, exerted exactly no control over the day-to-day movements, actions, uniforms, badges, vehicles, tools of its employees. They basically would allow Don and Austin Smith to go out to a job site and work as long or as short a time as they wanted, to undertake multiple jobs as long as they were all via Assembly 911 and not in violation of the non-compete agreement. At the same time, they could be building 4 sheds in different locations. They could do 1 shed at a time. They could take a opportunity to build 1 shed a month, or they could build 50 sheds a month. That was all to be determined by Austin and Don Smith. Now, were there limitations on that? Well, sure, and one of them was the non-compete agreement, unquestionably signed by Austin Smith, unquestionably referring to Austin Smith as an employee for purposes of that non-compete agreement vis-a-vis the Assembly 911. However, that doesn't indicate the degree of control, at least in the court's mind, required to satisfy the control test. It is, in fact, a fairly standard practice among in certain business engagements to have employees, or for that matter, prospective employees or customers, sign non-compete and non-disclosure agreements so that you don't use to your competitive advantage information that's gained. The most obvious information here would be, hey, why am I giving Assembly 911 a cut of my money, or allowing them to get a cut of Tough Shed's money? Why can't I just go straight to Tough Shed or Home Depot and say, you know what, I'm out here too. I'll build the Michigan sheds. Let's cut out Assembly 911 in the deal. Understandably, 911 might want to limit the ability to do that, or attempt to do so through a non-compete agreement. And even if they are employees for purposes of the non-compete agreement, they still might be, and the court's ruling will be, that they are independent contractors for the purposes of the liability sought to be imposed in the current case. And number 2, as I said, is payment of wages. That is undoubtedly done by Assembly 911 directly to Don Smith. In this case, as I said, if that were the only factor, this wouldn't even be an argument, but it's not the only factor for the court to analyze here. And I will note, also in the payment of wages, it appears that wages a set amount. It doesn't appear that, there's any performance bonus if you do X number of sheds faster or slower. There's no testimony as that. It appears that you bid on a shed, you know how much the job is going to give you. Presumably an independent contractor like Don and Austin Smith say, well, this is a lean-to or an easy shed. I can do it in a couple hours, and thus, and I think the contract specifies a minimum of $250. And one can imagine you wouldn't want to take a build in Ironwood of a 3-story barn shed for $250. That would be stupid. And notably, they were free to, as independent contractors, to say, no, I'm not going to go to Ironwood and build that shed. Find someone else. Find someone in Minnesota or Wisconsin or someone that's on your list to build that shed. That one isn't one that we're going to do. And though if you were an employee, that would get you fired. That wouldn't happen. Presumably with Assembly 911. Now, Assembly 911 might say at worst, I'm not going to give you any more Michigan builds if you won't do the Ironwood shed, but they didn't even exert that level of control. It appears that, the decision about which jobs to take and where those jobs were located was left entirely to Austin Smith and Don Smith, and to the amount of effort they provided on a particular job. And I guess that plays into number 3, the right to hire and fire and the right to discipline. Of course, when you have an independent contractor, you're not, although, as a lawyer who sometimes, I suppose, worked for my clients as an independent contractor, I always referred to it as getting fired by a client if that was threatened. In reality, they're not really firing you like an employee. They're just terminating their independent contractor relationship by not sending you additional work in the future. And that is a key difference there. And of course, accordingly, though they might be protected, and I guess I can touch on the question of insurance at this point, because that's argued and has been argued in oral argument today by both sides. Well, 911 does carry insurance. It's required to, in fact, in its contract for both automobiles and general liability, as well as workers' comp covering these employees. Well, there are multiple reasons why a company may decide to obtain insurance. Generally, the core reason there is 911 said, well, we're doing it because Tough Shed tells us to. And that certainly might be true. And Tough Shed's basis for doing so undoubtedly is the protection of Tough Shed and Home Depot, not any concern about 911. 911 dutifully obtained the insurance. And though, it says it's not for coverage or anything, with regard to workers' comp insurance, one can certainly imagine why that would be required. And that would be because workers' comp, of course, has a whole different standard as to when a person becomes an employee and when they're doing the work. And it would be conceivable that if a person didn't have independent comp insurance, that guy building a shed in my backyard, when he puts a screw through his big toe and can't work for the next 3 years, would be my responsibility as my employee. I certainly don't want that. I don't know whose employee he is, but I certainly don't want him to be Judge Rossi's employee when he's building a shed in my yard because I hired him through Home Depot or whoever. And so some provision of, for example, workers' comp insurance would be expected. I can't comment on, the idea of automobile insurance. And although I will note that the policy does very explicitly say if these are company-owned autos, they need to be listed on the policy, and then some coverage needs to be provided for non-owned autos, as was the case in this case. And for that matter, one can envision a case exactly like this, where there is a non-owned auto, perhaps was required to be insured under Michigan no-fault law or other provisions of law, and was indeed insured by Don Smith. However, is a non-owned auto vis-a-vis the company, and certainly the company doesn't want to bear at least primary liability and ideally no liability for that automobile, even though the automobile is being used by its subcontractor in furtherance of the work of all the companies here together. So with regard to number 3, the right to hire and the right to discipline, I cannot see that Assembly 911 exercised that at all. It certainly did agree to hire and then allowed other entities to perform background checks and give approval to Austin Smith and Don Smith as independent contractors. It never fired either of them. It appears that Austin Smith voluntarily stopped accepting contracts, and Don Smith perhaps filled that role or stepped up to the plate and got access to the app at some point. But even that doesn't indicate hiring and firing in the traditional sense, but rather is, as I referred to earlier, a characteristic of what's now referred to as gig work, where Don Smith says, you know what, I'm going to do some builds even without my son Austin, and here are the ones I'll take. And we don't know if Don Smith, increased, decreased, or whatever the amount of builds he was doing, nor do we know the reason that Austin Smith decided not to build sheds anymore. Was it because he got hit by a shed when the accident occurred and injured by a shed and harbors bad feelings towards the shed company? Well, of course, we don't know the answers to those questions. Finally, the most ambiguous portion and broadest portion of the economic realities test is number 4, and that is the performance of the duties as an integral part of the employer's business towards the accomplishment of a common goal. Well, if I only read towards the accomplishment of a common goal, we all could potentially be employees of a lot of different entities out there, because, of course, people work in many contexts towards the accomplishment of a common goal. And undoubtedly, there was a common goal here. Whoever started and sold this shed, Home Depot, those beautiful sheds you see perfectly square and plumb and built on their lot, when you drive up, their common goal is to sell one of those to the customer and to deliver it built on the customer's not level and rodent, gopher infested territory as best they can to the customer's satisfaction. So the customer says to their friends, hey, their neighbors, I got this beautiful Red Barn imitation at Home Depot for $1,500 installed and built. You can do that too. That is a very broadly writ common goal. However, if I refer to the first portion of that sentence in prong number 4, it's the performance of the duties as an integral part of the common goal. And that refers back to the duties referred to in number 1, again, the control test. In that, yes, Austin Smith and Don Smith and Assembly 911 were all working towards the common goal of getting these sheds built and finished to customer satisfaction in fulfillment of what a customer had already paid for. However, as I said before, the way those duties were performed, the timeline it took to perform them, those certainly weren't governed by Assembly 911 in this matter. They were, if they were governed at all, it was by Tough Shed and the people at Home Depot saying, well, of course, when we tell a customer we're going to have a shed and they buy it, has to be within perhaps a reasonable amount of time, or within 30 days, we'll get an assembler out to your property and to do that. And one can imagine that customers probably, depending on the situation, may even negotiate that with Home Depot or downstream. The Home Depot may send them to Tough Shed, and Tough Shed may say, well, I got a guy or whatever. But in any case, that none of that appeared to be the case here. There doesn't appear to have been any extra exertion of control of these duties towards the assemblies of the 2 sheds. And I will note, in reading the briefing last night, I did note, an important factor, at least as far as I'm concerned, is giving the benefit of the facts as the court must at this point to the plaintiff and to the Smiths. Well, they were going from one Tough Shed build to another, and the second build, appears to have been one that was left incomplete. There is ambiguity as to whether the first build was finished, and a distinct lack of records produced in the matter regarding the location and whether shed number 2 is really a Tough Shed or not. And I guess that would have been argued in the second motion that was up today, but won't be necessary given my ruling here. But I guess the bottom line is these 2 contractors at some point decided, I'm going to change from doing one job to doing another job. That's what I'm going to work on. There's no indication that 911 intervened, called them, texted them, apped them, and said, go and do this. But rather, this looks a little bit more like that gig work that I talked about, where perhaps they finished a job on one build or got to a stopping point on that. And they looked on the app and said, oh, here's another one that we can pick up. Let's go do that and do it right now. And that's what, inspired or they were controlling. In other words, the fact that they were moving from one job to another. It wasn't at Assembly 911's behest, the time that they did that, the way that they did that, whether the job was adjacent or whether they had to drive a vehicle from one to the other. It simply wasn't anything that Assembly 911 had control over. So for all of those reasons, I will grant Assembly 911's motion for summary disposition based on MCR 2.116 C10. There being no question of fact that a jury could decide that these people, that is Don Smith and Austin Smith, were employees and not independent contractors under the facts as presented by the parties to the court. Will you, Ms. Berlin, issue me an order just stating on the record?
I will, Your Honor.
That would be outstanding. Thank you all for the detailed briefing and exhibits in this matter. Boy, it was an introduction to the modern economy that I suspect I'll wrestle with again. So it was extremely well briefed and argued by both sides.
Your Honor, when we're off the record, I have a question for you. It's unrelated to this case. If you have time, it's real quick.
Yeah, no, I do.
Okay.
I'm only missing lunch, Miss Berlin.
Okay, I'll make it quick.
Welcome to the gig economy where nobody owns the app. Building little wooden sheds caught in a liability trap. You get a direct paycheck, but you are not on the team. Assembly 911 is just a corporate shell dream. So grab your hammer and your non-auto too. The judge is missing lunch and the light